Did you follow this? Did you follow this short video? So it is saying, they are mentioning about a flower vase which is fallen down, got broken, and the cat is sitting there. Nobody had seen how the flower vase fell down. But it could be the cat also. So circumstantial evidence is when nobody has seen the occurrence. There is no eyewitness to it. But what story is being told by the circumstances? Another important thing in this video was, you have to draw inferences from these circumstances, and based upon those inferences you draw a conclusion. So one circumstance is never enough, so there have to be more than one circumstance. For example, if somebody is seen near the dead body, you simply cannot charge sheet that person, send him to the trial and convict him, because there is only one circumstance, a person seen near the dead body. You have to collect more evidence. What was the motive, for example? Now there is a saying that witnesses may lie, but circumstances do not. It is a very common aspect of day-to-day life that people are falsely implicated in cases. So in cases of direct evidence, wherein somebody comes up and says that I witnessed the incident, one should not convict the accused solely based upon the eyewitness account. There are different tests employed to check the truthfulness or the veracity of this witness. Now for circumstantial evidence, let's have this small PPT. Circumstantial evidence, witnesses may lie but circumstances do not. The IO has to see who was it, when was it, and where was it committed, the crime, how it was committed, who has committed it, where it has been committed, and when it was committed. May we have the next slide, please? Phases of a crime. Kindly see, a crime is committed, it is investigated, a charge sheet is filed, charges are framed, and the last step is that the accused is sent to face the trial. So this is the process in brief. Now what are the elements of a crime? So there has to be, we are focusing on murder. There has to be a weapon with which the crime was committed. There would be some suspects. Evidence would be collected. There could be a confession made by an accused person, and there could be motive for the commission of a crime. Now motive. Now in Urdu there is a saying, if a crime is committed, generally there could be three motives. They say zan, zar, zameen. So zan is like there could be involvement of some lady, for example. It could be a crime of passion. Zar is wealth, so it could be a crime committed for some pecuniary interest, and zameen are the property based offences. So this is narrated here also in this slide. It could be related to some property, it could be some kind of a situation where there could be some relations between two people and a third person is murdered, and it could be because of money. These are the common motives. Now the investigation commences. It relates to identification of suspects who actually committed and compilation of different evidences. Please remember, you cannot charge somebody based only upon one circumstance. Alright, now as you can see, what roles are committed. Like there would be an investigating agency which could be the police, CBI, CBCID. There would be an accused, the murderer. Then there would be prosecutors who would be prosecuting. Those are the state lawyers. And of course the courts which would be adjudicating. So they are the parties involved. Now these could be the various kind of weapons. Murder could be by a gun, knife, axe. In rural settings we come across many different kinds of weapons. We hear new names like sabbal and tabbal, baka, lathi. So they are used in rural settings. Poisons are also used. So that is just parts of a gun, which is very important in the medical legal aspect. Yes. Confessions are also made. Now the investigating agency, they generally take suspects into custody and they often make a confession to the crime. Now that confession made in police custody is not admissible. आप confession पे सजा नहीं कर सकते. But what is admissible is if based upon the confession there is a discovery of a fact. Now that fact is admissible. For example, if the person says, I have murdered Mr. A and I can lead you to the place where I have buried the body. Now, I have murdered A is not admissible. The body is also not admissible, that place is also not admissible, but the fact that this person knows where the corpse is, that fact is admissible. For that, section 25, 26, 27 of the Indian Evidence Act are very relevant. So again, these are the questions. Now you can see what could be those circumstances. So there could be fingerprints, there could be boot marks, there could be DNA analysis. Apart from that, with modern technology, there could be your call detail records, that there was some communication going on between people. The mobile phone could pinpoint the location of the accused, whether when the crime was committed, he was with the victim or not, where he was positioned. Or if the crime is committed in Lucknow, the mobile location shows that the accused is in Calcutta. So that could be an alibi for the accused, proving his innocence. So you can see there could be DNA fingerprinting, there could be drug analysis, forensic pathology. So these are the medical legal aspects which came into picture in that case of dentist, and also in IIT IIM graduate case, and Shakira's case also. So these are some statistics that drug related crimes are 15%, violent crimes are 20%, property related crimes are 60%. Now that's me. So this was basically relating to a PPT presentation on circumstantial evidence. Alright, now let us go back. A dead body is suppose found just outside this room. Information is sent to the police. An investigating officer is appointed. He comes here. We all are here. A murder is committed. Body is just outside in the plants. None of you had seen the murder. If Azhar had seen the murder, it would be a case of direct evidence. Now, while a conference is going on, when the conference ends up, body is found just outside. What would be the duty of the investigating officer? You all would be the first suspects. Alright, what would be your alibi? Each one of you can testify, no, we were here. Now this is being recorded. This is recorded. So your presence is shown here when the murder was committed. But then who committed that murder? So what would the investigating officer be looking for? So he might find a murder weapon. Suppose there is a knife with blood stains next to the body. So what will he do? He will secure that knife, make sure evidence is not destroyed, and send it to the laboratory to find out whether it contains any fingerprints or not. It could contain the fingerprints of the accused person, which can be matched with the fingerprints of the suspects. The investigating officer would also try to find out whether if there is soil there, whether there are any shoe marks or not. If shoe marks are there, then he'll try to find out whose shoe was it. We could be ruled out from the shoes which we are wearing. We could become a suspect also. He might ask a scientist, a forensic scientist, to take custody of the clothes of the deceased, send to the lab, find out whether there is some DNA there or not. There could be fur on it. Fur might belong, say, to a dog. And one of the suspect has a dog. So that was carried from the clothes of the accused to the clothes of the deceased. There could be DNA which could be collected and analyzed whether it belonged to the deceased or the accused. Suppose if there was a fight between them, the accused also got injured, leaving behind some DNA, potential DNA. Once he has collected all these different kinds of evidences, there could be call detail records, placing one suspect at pack and shoot, ruling out the presence of other suspects. There could be some recorded conversation of accused conspiring with other persons to eliminate this person. That might have been recorded by chance. That would become another circumstance. when all these evidences are collected, an inference could be drawn. Now, you know that there's a difference between clues. Clues could be the knife, the fur, the DNA sample, the motive, etc. Inferences could be A, B, and C are potential suspects. A might have, B would not have, C may or may not have. Then comes the stage of conclusion. B, C are ruled out, A has committed the crime. So a charge sheet is submitted. These are the circumstances against this accused person. Matter is sent to the court of law. The court of law, all these evidences are placed before the court of law. A, B, C, D, E, these are the evidences. Now, how would that trial judge decide the trial? Is there any law relating to how the trial judge can go about deciding the trial based upon circumstantial evidence? So you must have read Shraddhanand Sharda. In that case, 5 golden principles were laid down by the Supreme Court of India to decide cases based upon circumstantial evidence. So let us see this. This is Shraddhanand Sharda.